In this video lecture, I'm discussing civil rights and African Americans. One of the strange things about history of the United States is its race-based institution of slavery. Now, the reason why this is a little bit strange in the larger historical context is because slavery used to be a universal institution or a nearly universal institution. In the ancient world, we cannot find a single surviving written document that condemns slavery. Not a philosopher, not a politician, not an ordinary citizen is on record in the ancient world condemning slavery. And in fact, the institution was so widespread that when the Romans came into contact with the Germanic tribe called the Alans and discovered that the Alans had no slavery, the Romans were shocked. So this institution was virtually ubiquitous in the olden days. But the United States is different in that slavery was race-based, and that it arose at the time when it did not exist in the colonizing countries, that is to say, in the countries of Europe themselves, in Spain, Portugal, England, France. There was no slavery, yet these countries participated in the slave trade. Now, the first slaves from Africa came to the colonies in 1619 on a Dutch ship. They were brought to Virginia. At first, there was some reluctance to purchase African slaves because they did not speak English, they did not know the culture, and plantation owners preferred to rely on indentured servants. Indentured servants were people from Great Britain who were sent, they were convicts who were sent to work the plantations in the American colonies. And it's interesting that some people have actually sold themselves voluntarily into indentured servitude and were not convicts. Some young men, seeing no prospects for themselves for new life, would sell themselves to the captain of the ship. They would essentially say, I cannot pay fare because I am poor. Once you deliver me to the colonies in North America, you can sell me, and the sale would be generally for the period of 7 years. And after that, the indentured servant would be freed. We also have to note that early in the 17th century, it was also very common to free African slaves. The idea was once they have worked for a number of years, they got older, they got tired, they would be replaced. So a common practice would be to free slaves, and an even more common practice would be to free indentured servants. This created an unexpected problem for societies, for the colonies, particularly southern colonies, because even though slavery was legal in all 13 colonies, well over 90% of slaves were brought to southern colonies because that's where the large plantations were, and that's where the most productive agriculture was. In the north, slavery existed, but on a very, very, very small scale. Very few families owned slaves, and those rare families that did own slaves typically owned between 1 and 4. In southern states or colonies, the situation was completely different because of large-scale agriculture. But already by the end of the 17th century, this presented a problem because freed indentured servants and freed slaves would move west in order to settle what they believed were uninhabited and unowned lands, and they would clash with Native Americans who saw that land as their land. So in order to protect them from the Indians, indentured servants asked the government of Virginia, at the time led by Governor Berkeley, to protect them from the Indians. And the governor refused because he did not want the war with the Indians, because the upper classes of Virginia did not want to tangle with the Indians for a war which they might not win. And they didn't feel that they had their own particular interest in that war. So in order to fix the situation, so to speak, the freed indentured servants and the freed slaves who sought protection from the Indians found an unlikely leader for their anger. That leader was Nathan Bacon. He himself was an immigrant from England and an aristocrat, neither an indentured servant nor a slave, but rather a representative of the upper crust of the British society. He immigrated to America and he resented the so-called new aristocracy of Virginia, who were rich and often self-made and made their wealth in commercial activities, and Bacon disdained them because in his eyes they were not true aristocrats, and it was very kind of interesting, it was bizarre that this group of white indentured servants and black former African slaves were led by this British aristocrat in a rebellion against the government of Virginia. Bacon's rebellion of 1776 and 1777 was so violent that it nearly destroyed Virginia. And after this rebellion, the ruling classes of Virginia, and in fact of the entire colonial world, saw that there was a problem, and the problem was labor. What is going to happen in the future? If we have this issue now, it's only going to get worse in the future. So the solution to this labor problem was to create the kind of labor that would never become free. And this is when, after 1677, the reliance on African slavery begins in earnest. Indentured servants are phased out, and they're replaced by African slaves, and it becomes almost impossible to free a slave. It becomes legally very difficult, and it becomes financially very difficult, very unprofitable to do so. So this is where reliance on slavery begins. Importation of slaves escalates, and by the time we get to the Constitutional Convention of 1787, we have slavery that's legal in all 13 states, but once again, it's mostly concentrated in southern states. Now, how did the Constitution deal with this issue? First, the Constitution said that importation of slaves cannot be prohibited until 1808. Okay, so they basically gave themselves 30 years to protect importation of slaves. Second, for the purpose of both representation and taxation, they decided to count slaves as 3/5 of a person. This was because southern states wanted to count slaves as one whole person, and northern states that had almost no slaves wanted to count them as 0. Southerners were very afraid of being greatly outnumbered in the House of Representatives. For this reason, they wanted to count each slave as one person. The Northerners wanted to count slaves as 0, but the compromise was 3/5. So this is what can be said about an initial effort to deal with the issue of slavery. They understood that they couldn't accomplish more. They couldn't insist on the abolition of slavery, because if they did, then southern states and border states would never have agreed to ratify the Constitution. Now, the next stage of the problem arose as a result of territorial expansion. After the Louisiana Purchase in 1803, the size of the American territory almost doubled, and it was only a matter of time before those territories would be parceled out into states and the states admitted into the Union. So the question was, if you admit these states into the Union, are they going to be free states or slave states? And in 1820, we had an answer. That answer was the Missouri Compromise. The Missouri Compromise said that there will be no slavery in the states that are located north of the southern border of Missouri, except for Missouri. There is, once again, no slavery north of the southern border of Missouri, except for Missouri. That would be the last one. And everything that's up north will have no slaves. That was the Missouri Compromise. However, as you might imagine, this compromise would not last. After the Mexican-American War and the Treaty of Guadalupe Hidalgo in 1848, Mexico was forced to sell vast tracts of new land to the United States. And it was acquisition of these new territories that once again brought up this question. What is going to happen when these territories are parceled out into the states and the states enter the Union? Are they going to enter as free states or slave states? And it was, in fact, the entrance of California into the Union as a free state in 1850 that broke the parity in the Senate. Prior to that, there was even number of free states and slave states, and so there was an exact balance in the Senate between free state senators and slave state senators. The entrance of California into the Union in 1850 broke that balance and heated up the disagreement in the country over the issue of slavery. Southern interests became gradually more paranoid. I also should note that even at the height of slavery, now in the 19th century, we're talking about, even in the South, the vast majority of the families did not own slaves. Only approximately 20, maybe 25% did. And among those who did, only a small percentage, maybe 5%, were plantation slavers, were slave aristocracy, like slave aristocracy, like Thomas Jefferson or James Madison. So these people literally owned hundreds of slaves, but most people who did own slaves, and they were, as I said, a small percentage of the population, they owned a very small number of slaves. So tension heated up, and it particularly became prominent when a new political party was formed in the early 1850s, and that was the Republican Party. The reason why was because the Republican Party was openly anti-slavery in its sentiments. Its first candidate for president, John C. Fremont, lost to James Buchanan in 1856. And so it seemed like maybe for a while nothing major would happen. But the problem was that by then all the northern states had abolished slavery. Slavery remained only in southern states and in the four so-called border states, i.e. Missouri, Kentucky, Delaware, and Maryland. So having abolished slavery, there were now two distinct types of states, those that had it and those who didn't have it and had significant moral hostility to it. So in 1860, during the election of 1860, the issue of slavery became the key issue, really. And now the Republican candidate was Abraham Lincoln. Lincoln made his position clear. He said, I want to protect slavery where it already exists. In fact, he even proposed a constitutional amendment that would protect slavery where it already existed, but no slavery in new states and territories. This was completely unacceptable to southern states because they were afraid that they would be geographically, economically, and culturally isolated, and they would not be able to maintain their system if this were the case. So the problem was the election of 1860 led to an internal split in the Democratic Party, the party that opposed Lincoln. It was split three ways. The main opponent of Lincoln's was John C. Breckinridge, a 39-year-old former vice president who actually was very obviously pro-slavery and very obviously represented Southern interests. And then there were two other candidates, John Bell and Stephen Douglas. Both of those emphasized the importance of maintaining the Union and not putting issue of slavery in the forefront. So because of the split, because of this three-way split within the Democratic Party between Douglas, Bell, and Breckinridge, Lincoln was able to win the election with only 40% of the popular vote. But that didn't matter because he had more than enough. He had 60% of the Electoral College vote. So Lincoln was elected president, and almost as soon as he was elected, southern states began to leave the Union. South Carolina left in December of 1860, and then 6 more states left in February of 1861, and then in March they created the Confederate States of America out of 7 southern states, and then later 4 more states, namely Arkansas, Tennessee, North Carolina, and Virginia, would also join them, bringing the total number of southern states to 11. I have to point out that some states that had slavery remained loyal to the Union. Which states? Well, I'm talking about the 4 border states: Kentucky, Missouri, Delaware, and Maryland. Even though the men from those states, some of them volunteered for the Confederacy and some volunteered for the Union, but technically all those 4 states remained in the Union during the Civil War. So it was the Civil War that actually ended slavery, and for practical purposes, and also the 13th Amendment, which was ratified in 1865, and that ended that institution. So the question for Southerners who wanted to redefine now this relationship that they had, how do you redefine the relationship that you had if you had a race-based slavery? The answer that they came up with was to import a system that already existed in northern states, and that was the system of segregation. So segregation and slavery are completely incompatible. The essence of slavery is access. You can always access your property. So you can imagine that slaves and slave owners lived nearby. The system of segregation, which Southerners had actually copied from northern states, presumes exactly the opposite, that there is a strict separation, in this case, between people of different races. And how was it actually implemented? The answer is on a state-by-state basis. Each state passed its own segregation law, and each law segregated a particular activity, a particular area of business. Segregation would, of course, be legally challenged, and the case that challenged it was Plessy versus Ferguson. It was decided in 1896, and Homer Plessy was a French-speaking Creole from New Orleans who looked white, but he was 1/8 black, and as such he could not sit in a train car with white people. When he was asked to leave, he refused. He was taken before a judge. The judge's name was Ferguson, hence you have a case called Plessy versus Ferguson. This case would go all the way to the Supreme Court, and the Supreme Court had to answer the question: is legal segregation of races constitutional? Well, let's ask ourselves this: why would it not be in the Constitutional? Where in the Constitution might we find a provision that we can argue rejects segregation? The answer was the Equal Protection Clause of the 14th Amendment, that says that no state shall deny any of its citizens equal protection of the laws. And the question was, what does this exactly mean? Does it imply that segregation is not allowed? The Supreme Court answered, well, it does not imply that segregation isn't allowed. Segregation is perfectly fine, separate but equal. In these lectures, we already met this way of interpreting the Constitution. It's called doctrinalism. When we talked about the doctrine of innocent purchaser in Fletcher versus Peck, or when we talked about Everson versus Board of Education and a wall of separation. That's the doctrine 2. Here we see a different doctrine. We see separate but equal. What is it? It's a constitutional doctrine. What is it meant to interpret? The Equal Protection Clause of the 14th Amendment. That is why the doctrine is called separate but equal and not something else like separate but fair, separate but strange, separate but what can we do? Let's put up with it. No, it's called separate but equal because it refers specifically to the Equal Protection Clause of the 14th Amendment, and the court said if the facilities for different races are more or less equal, then segregation by race is constitutional. So Homer Plessy lost this case. The system of segregation was preserved. There was only one dissenting opinion in this case, written by Justice John Marshall Harlan, who said, "This is a shameful decision, and it will go down in history as such, just as Dred Scott versus Sanford did." Well, what was that Dred Scott versus Sanford decision to which Justice Harlan referred? That was the decision that the Supreme Court made much earlier, in 1857. In that particular decision, Justice Roger Taney, speaking for the court, wrote that people of African descent are not and can never become citizens of the United States. Now, that particular decision divided the country even more than the country was already divided, and helped to usher in a crisis that led to the Civil War. And here, John Marshall Harlan was saying, well, things are going to get as bad as with Dred Scott versus Sanford. This decision is morally shameful, and mark my words, in fullness of time, it will prove unworkable. The Constitution, he said, is colorblind. And that was a pretty remarkable opinion. We have to keep in mind that Harlan himself was a former slave owner, but he insisted that the Constitution recognizes no race. In the eyes of the Constitution, all people are equal, and no one is inferior or superior in the eyes of constitutional law. You can have any opinion that you want about race, but the Constitution does not recognize superiority and inferiority of races. Okay, so the decision was made in Plessy versus Ferguson. The segregation system would be in place for many decades because of the separate but equal doctrine. In Brown versus Board of Education, a case that most of you are aware of, which was decided unanimously by the Supreme Court in 1954, segregation in public schools was declared unconstitutional based on the premise that children who were subjected to a segregated system of education experienced psychological pressure that marked them with a badge of inferiority. So if you're forced to separate by race, then that's inherently unequal, and it would not matter even if the facilities are technically equal, even though, of course, in most cases, they were not really equal. But the court said, even if they are equal, it doesn't matter. It still is unconstitutional to separate by race. Why do I say this decision, even though obviously it was an important decision, and the court deserves a lot of credit for issuing a unanimous one, because if the court were divided like 6-3 or 5-4, then I think more legal battles would be ahead, because the forces of segregation would say, see, the court is very narrowly divided. It might overrule itself in a few years. But a 9-0 decision signaled to the country that this is going to be a permanent change, and that it is almost certainly not going to happen that the court would eventually overturn its own decision. Why do I say the decision was somewhat limited in application? Well, because it pertained only to public schools. What about other areas of human activity? What about theaters, restaurants, hotels, motels, etc.? Well, the answer is they remained segregated because they were not public schools. And it would not be until the 1964 Civil Rights Act, and then, as you might remember, Heart of Atlanta Hotel versus United States that we discussed previously, it would not be until 1964 that the law would also desegregate facilities that served the public but were owned privately. But the decision in Brown was still extremely important because it helped to usher in the civil rights movement, which lasted from 1955, beginning with the Montgomery bus boycott and ending in 1968 with the assassination of Martin Luther King in April of that year. What was at the heart of the civil rights movement? Well, first of all, we would be wise to define a social movement, because the civil rights movement was a variation of a social movement. What is a social movement? It's a movement that includes in itself millions of participants from many different walks of life. So movement by definition has mass character. It is not limited to professional activists or to journalists or to judges. It really has a mass character. Lots and lots of ordinary citizens from many different walks of life participating to make a change. And the Montgomery bus boycott that was successful, and subsequent Supreme Court decisions, and also, we should note, congressional laws. We talked about the 1964 Civil Rights Act. Also, the 1965 Voting Rights Act was very important. Prior to the late 1960s, African Americans could not vote because of various barriers to voting, like literacy tests, poll taxes, intimidation. But all of this would end with the 22nd Amendment to the Constitution and with the Voting Rights Act of 1965. The Civil Rights Movement employed a variety of techniques like sit-ins, protests, marches, and freedom rides in order to effect a change. So freedom rides, for example, would involve people of different races riding interstate buses from a state in which segregation didn't exist into the state where it did, in order to highlight the unfairness of and ludicrous character of segregation. Marches like the Selma series of Selma marches were marches in order to demand the right to vote. Protests and sit-ins. People, for example, of different races would go into a segregated diner, so they would have lunch together, and then segregationists would pour ketchup on their heads, would throw Coca-Cola in their faces, and they would not move. They were trying to show that they're just peaceful resistors, that they want positive change, that the other side were the monsters, the other side was intolerant, and it's the other side that was against justice. They were for justice. So this is what you have. And why do we cut the line? Well, I did, and many others do. Why don't we say that the civil rights movement certainly continued after 1968, and some say, well, continues today because look what's happening, let's say, with minorities in the police, particularly a number of incidents involving police shooting unarmed African Americans. What about that? Well, one of the things about the civil rights movement is it has a narrow range of goals. In fact, it had two specific goals: to end legal segregation, that was one, and then to allow African Americans to vote. So the original civil rights had these two specific goals, but also it had a specific method, and that method was civil disobedience. After Martin Luther King Jr. was assassinated in 1968, 100 or so cities and towns erupted in riots. So the peaceful character of the movement ended. That's number two. First, there were two very specific goals, both of which were accomplished. Second, the nonviolence of the movement ended in a lot of violence. And third, now there were new goals. Some people tried to posit new goals like affirmative action, and that was much more controversial to be so widely supported. On issues like affirmative action, the country was and still is roughly evenly split. So there wasn't as much of an agreement on that. So that's why some people like myself cut the line and say, well, the original civil rights movement was 1955, 1968. Thank you.